If you work at the intersection of education and copyright, you almost certainly have run across his name, if not his person. He's been an advisor to the project on the tangled issue of copyrights and syllabi for us over the last year, and I think we'll sort of lay out the issues, both the copyright issues as Kenny knows them, and then some of the just pragmatics of how we've tried to engage with different institutions at different levels, and how we've tried to build in systems that make it easy for, or that we hope make it easy for universities to say, yes, we'll hand over our syllabi, and easy in the sense of providing them some assurance that this isn't going to come back to bite them immediately when faculty get angry that suddenly that some things about their syllabi have appeared in contexts that they don't control. So I'll let Kenny start, and then I'll follow up with a bit more of the life as we've known it in the last year with the the social and legal complications of the project.
Well, very good. Thank you, Joe. Thank you. Thanks for the invitation. Thanks for the opportunity. Thanks to all of you for being here. I really appreciate it very much. I think what we're going to try to accomplish, I think our primary task, is really to take the copyright issues and related issues associated with syllabi, with the project, and try to shake loose some of the mythology surrounding copyright, put in its place a framework of thinking about the issues, but then really reach out beyond copyright and look at some of the practical challenges of decision making about copyright. So it's one thing to say somebody owns the copyright. That also raises implications about who makes the decision, who has responsibilities. It's one thing to say that there is fair use associated with the use of somebody else's copyrighted work. But then again, it begs the question of who really makes that decision and how is that decision made. And sometimes that is as complicated as the question of what is fair use anyway, the question we have to ask up front. And then, Joe, as you were suggesting, it's a lot more than copyright, and it's a lot more than law. It's often in this context a question of diplomacy and decision making inside the organization. So the context where a lot of this comes up is in that setting where, as a project, an important research project with extraordinary potential to support education in many ways, needs access to these tens of thousands, if not more, hundreds of thousands of syllabi that are located on university servers. So we can do legal analysis, and we're going to do a little bit of that legal analysis right now. So we can do legal analysis, and we can see where the answers might lie. But there's another question, and that is making the decision within the institution to just permit that access, which may not be a decision maker who is, in fact, the legal rights holder. So we also need to keep in mind we're talking about not just the legal rights associated with documents, but we're looking at questions of who has authority to make decisions about the legal rights and about access to those documents in the first place. Now at this point, you're probably wondering who invited this guy into the room and when will he go away? And I don't take that personally, so that's all right. That's all right. So I've just cleared the air for your first set of questions, right? Because that's all right. I'll be the first to say that the law doesn't work very well. Is that a polite understatement? In a lot of contexts. But then again, we don't have to think very far to say, if I were somebody else in this set of events, if I had a slightly different attitude, I might see this all very differently. And that's part of the task, too, of being the legal person who comes to these transactions, is really pausing to say, regardless of what I think, what I believe, we need to see things through somebody else's eyes. So let me get down to business. I'm going to kind of switch into professor mode, if you don't mind, and talk a lot about how copyright works. I might be jumping over to the whiteboard to do some of this, and I say that as a warning to the camera person. That's okay? Great. So often for so long, like teaching many subjects, your way of thinking about the issues evolves and changes. Mine certainly. My views have certainly changed, and my understandings have changed. The law has changed, so we have to change with it. But also, I'm in a project like this, I break out of sort of that linear mode as well, and I think it's a lot of circles. We're going to be chasing a lot of things around in a circle, and somewhere in there, we need to make some decisions. So here's what I'm going to do, over to the whiteboard, and by the way, really good news. Both markers work. I mean, really, how many times have you gone up to a whiteboard and they're all just like dead? So we tested them first. So that wouldn't happen here, would it?
This is a first-rate operation, Kenny.
You've got it.
We don't have coffee, but we have.
And the coffee is on its way. That's what I hear. Yeah. So for years and years and years, teaching about copyright law, you kind of start at the beginning. Here's the quickie linear fashion approach to copyright. Starts with a set of questions. Is that work? Now pause here a second. Our subject is a course syllabus. Pick any of the ones that have been up on the board, old or new, creative, not so creative. Any of those course syllabi that you have encountered, that we saw this morning, whatever it might be. And if the question comes up, tell me about the copyright implications of this. It starts at the beginning. What works are eligible for copyright protection? And so, we have this eligibility question. And then we might move, if we did this in linear bullet points, is that work eligible for protection? Let me give you the answer to that right now. Copyright today protects original works of authorship that are fixed in a tangible medium of expression. Well, pausing there, I can tell you right now, nearly everything we've seen up on the board is protectable by copyright. It's an incredibly easy standard. Just about the only thing that maybe we've seen up there that isn't protectable is maybe the name of the course, maybe the name of the faculty member. That's about it. Authors and titles, those are typically not protectable. But in a description of a course, a sequencing of themes, an ordering of reading material, anything else like that, easily protectable by copyright. And then once it's protectable, if I were doing it linearly, the next bullet point would be, is it in fact protected? Let me give you a quick answer to that. The answer is yes. Because today, nearly everything that's eligible gets instant automatic copyright protection. So right now, shake out of your heads all these things you've heard, maybe heard in the past, like, well, it didn't have a copyright notice on it. For the most part, irrelevant, not even an issue anymore. The law just swept all that away. Maybe for some older stuff it was relevant. Yes, for some older stuff it was relevant. But for modern materials, not even relevant. So we go from eligibility to is it protected, and we get to that yes, really quickly. We get to just some yeses and yeses. So we're on our way. We're into copyright protection. And then once it's protected, somebody is the owner, and those ownership rights are broad. It has a set of rights, reproduction, distribution, derivative works, etc. And those rights last. The duration question lasts for a long period of years. Basic rule today, if I'm a faculty member, I write up a syllabus and a course description, I put in all this and that, and please read this and show up for class and all of that original stuff that I'm putting into my syllabus. How long is that? If it's mine, if it's my copyright, how long does that copyright last? Anybody know? I'll tell you. It lasts for the rest of my life plus 70 more years. Okay? That's a long time. And I get the movie rights too. So it's all mine. Of course, now we play it out in MOOCs, don't we? Those are my movie rights. I'm rich, rich, rich. So, okay. So we've got this bundle of rights. And then we're going to really say from that somebody is the owner. And we now say that if I'm going to use that work that touches on any of these rights, I'm going to need to reach out and find the owner and ask for permission. How many syllabi? 1 million, 1.5 million, some of those big numbers that we've talked about. So theoretically, it's tracking down those 1.5 million people and asking them permission. So I know, laugh track and capture it on the tape because it's a good thing. So we can see the unwieldiness of that. It just flat out won't work. So we have built into the law fair use. Now, we could go on all day about fair use and what it is. Couple key points about fair use. Fair use is built on 4 factors that are in the statute. It's fluid, it's flexible, it applies differently under different circumstances. There are, however many of us are in the room today, we'd have that many different opinions about what fair use means in different circumstances. You want real answers, go get yourself sued, hire a lawyer, get in front of a judge. $3 million later, you might have an answer, maybe. And so fair use is something that we need to understand, grapple with, and make really some important, reasoned, good faith, reasonable determinations about what fair use really means under different circumstances. And that's what we're called upon to do in all of our exercises of fair use. Now, the reason why it's a circle and keeps coming around is because we get into this circle because so much is protectable. So much is automatically, easily protected. And once it's protected, it's a broad set of rights that last for a long period of years. And those rights are vested with somebody that in this kind of situation, this kind of project, is almost always not me, not you, it's somebody else. So we're all thinking about somebody else. And then we have whatever degree of uncertainty goes with questions of fair use. And it's a circle because if we can really do some of this open publishing, open access, open approaches neatly, we complete the circle and we come back to the beginning. And we would say, in a perfect world, to people who are creating these resources, you have copyright protection because the law says so. You really don't have any choice in the matter. But where you do have a choice is where you can let go of some rights, either through individual permissions, but that's unwieldy to track all this down. But you can let go of some of those rights through licensing, such as Creative Commons licensing, so that we can begin this process of using this sort of project to persuade people back at the beginning that if you want to make your work valuable in the research context, in advancing education outside of just your one course, a Creative Commons license that permits the public. You're not letting go of your copyright. You're saying, I am the copyright owner, and I hereby know that I have these rights. I hold them over here. I know fair use is an uncertain question, so therefore I give you permission, like a CC license for non-commercial kind of uses could support all of this sort of activity with credit, where credit is due because you said so. You want attribution as well. That's a choice. And so that CC license can begin to fill this out as a circle. But let's talk about other pathways that might get us somewhere. Because we really there are more possibilities than this, but at least for starters, there are 2 possible likely owners under the law. One is the individual who is the individual who created that work? So this is a typical example. If I created it, I own the copyright. Because your basic rule is the person who does the original work is the copyright owner. Well, already you can begin to see, when I put it that way, that some of this starts to fall apart. Because a typical syllabus is pulled together from a multitude of different sources. Maybe if I'm the professor, I wrote that original set of paragraphs that introduces the course, and I wrote those in my own words. So that's mine. But you know, I then went to other syllabi, or somebody who taught the course before me or whatever, and I pulled out some of their content, said that's a great idea, and I plugged it in over there. And then there was this really cool cartoon, or this chart or graph that makes an important point, so I pulled that in. Now we can begin to see that maybe my syllabus isn't, even if I own the copyright in a colloquial sense, maybe that doesn't really cover everything. But what it does cover, that's really mine, that I really created, now we're at 1 million different people like me. And we're back to that unwieldy situation that I just made more messy for you. Or, sounds like a radio station, I know. WMFH. The work made for hire. Now, under the law, when a work is created, if it's eligible and is protected, it either belongs to the individual, or if it's a work made for hire, it belongs to the institution. So the institution, as the employer, if you are truly an employee, can hold the copyright. Think about the problems there. They're number one, oh my gosh. You may all watch as my caffeine level returns to normal. Basic rule of work made for hire, there are a couple of different versions, but one is if you are an employee and created that work within the scope of your employment, then the copyright in that work belongs to the employer. And there's a different version that applies to independent contractors, but it's more complex, it applies narrowly, and you can't do it by accident. It requires a written agreement of work for hire signed by both parties. So we're a lot less likely to come across that version of work for hire. So the employee version is the one that we're going to encounter vastly more often. So what does that mean? Some ways, it makes this whole project a lot easier. Because instead of having 1 million different individuals, we may now be down to 1,000 different institutions. Now the project looks, by comparison, a lot more manageable if we're dealing with copyright owners. But work made for hire has a problematic history in the university context. And usually in any kind of scholarly context, presentation like this with faculty, when we get to this subject, there's instant pushback on this issue. Because they will see it as the institution owning their works, controlling their intellectual creativity, et cetera, et cetera. All of these are really serious questions because it goes to academic freedom and so on and so on. So in reality, what happens is institutions by policy defer to their individual faculty and say, we leave to the individual the rights associated with their traditional works of teaching and scholarship and so on. So they leave it to faculty to be able to hold and exercise those rights. And that's a very, very common policy position for universities to stake out. So just when we thought we had it down to a more controllable number, universities very often push it back to the individuals. And once it's pushed back to the individuals, then we're back up to the 1.5 million different individuals. So it becomes a vastly more complex process. But once we identify these rights holders, then we can get to a desired end result by virtue of permission, or we can talk with these individuals, and a version of permission is a CC license or some other device for making that work more readily available. If we don't have any of that, then like so many of our projects in the academic setting, we turn then to fair use. And we need to figure out what fair use means, how it applies under these circumstances, and so on and so on. Pause for a second. The law is going to make most of these decisions back here. Is that work eligible? Then the automatic protection. This is what the law does. So the law is making a lot of these decisions back here, placing those rights with the owner. A lot of these decisions out here, is it work for hire? Are the rights sent back to the individual even if it is work for hire? Whoever the owner is there going to be a license? Is it going to be this? These are individual decisions. Individuals by individual people or individual institutions. Somebody over here, all those things I just mentioned in the last minute, those are all decision points that somebody needs to make. And if they don't make them, then it defaults to the law. The law just says somebody owns it, you got to figure that out. And so, well, we can figure it out. But it means that we're not necessarily getting the result we want, we're getting the result that the law gives us. One of the things I like about copyright at this point is there are choices under the law, and that the law lets us come to different conclusions. But we have to do some work to come to those conclusions. They will not happen by accident.
Excuse me, I don't want to interrupt, and
Please.
I hope I'm not stealing your thunder, but I'm curious as to this, when the difference, just the dichotomy between private and public institutions, when does that status start to affect how the law looks at ownership?
Yeah.
Especially particularly in higher education, public university versus a private university.
So far, no difference.
Okay.
And one place where I had to point out the difference is I gave a talk at the U.S. Naval Academy. And talking through some of these issues, and I actually had to stop and think, oh, you know what? You faculty at the U.S. Naval Academy, you are all employees of the U.S. government. And because of that, your works are not even eligible for copyright protection. I had to break the news to them that all that fighting for copyright ownership may be totally in vain because their works are maybe completely in the public domain. That's one of the important exclusions from copyright way back here. But once a work is in the system, eligible, protected, we're not going to get a difference out here.
But to be clear,
Go ahead.
If you work for a public university, you're not an employee of the government.
Good
That
question.
only applies to the
Good.
Naval Academy.
Good question. I'm gonna really clarify it this way. That exclusion, there's an exclusion in the Copyright Act that says there'll be no copyright protection for works of the U.S. government. So, Naval Academy is a part of the United States national federal government. Those works can be in the public domain. The works produced by the state, somebody at the State University of New York, for example, fully protectable. No issue, no difference whatsoever. Same as the works produced by people at Columbia University. Same issue. I think that goes to your point.
And is that what was decided with the UWM system when they were...
UW-Madison? Is that what you're referring to?
University of Wisconsin, the system was, asked to provide syllabi for a teacher's organization. I can't remember which one, but...
You mean all faculty were ordered to hand over their syllabi, something
we'll
like
take
that?
this offline.
I can't speak to the particulars. I hope you'll bring it up later. Yeah, I can't speak to it. But then we come down here to fair use. And if we're going to say, oh darn, all of those works are to some extent protected by copyright, and there are thousands or millions of them, we can't go track down rights holders, we're not even sure who they are, let's exercise fair use. So the permission is a set of decision modes, decision points, and the question of, okay, well, is it fair use? That's a decision point as well. So how do we analyze fair use? How do we conclude what is or is not fair use? Who gets to decide whether it's fair use for purposes of binding the institution? Those are critical questions, and typically, I won't speak to any particular university, but I know from working with many of them across the country, when you get to this nitty-gritty, the point is that there's really only one office that's authorized to give legal advice on behalf of the institution, and that's usually the Office of University Counsel or General Counsel. So now, so the decision ultimately, green light, etc., on fair use, very often resides with the Office of General Counsel. Unless, of course, it's mine. If it's mine and it's out of this system, it's not owned by the university, then the question of whether, it's the use of my work, permission is the easy way out. But if it's your activity, your project inside the context of an institution, you're really looking at getting institutional approval to be able to exercise fair use. And then we have the question of, again, sort of chasing this into circles. What are other choices? There are other exceptions under the Copyright Act. Some of them, probably not many of them, have any real relevance to this particular project. But so we're looking at the question of not only here, what is fair use? How do we determine fair use? And who ultimately gets to make that decision about fair use? Then layer on, this is the last point of sort of the circular tutorial. Layer on the question of how do we get access to it? So even if we have tens or hundreds of thousands of syllabi inside of a course management system that are not publicly accessible, who is going to ultimately approve access to that content? That's separate from the legal question. Layer on the legal copyright question. Layer on top of all of that the diplomatic question. Because we all know, as alluded to briefly this morning, that a lot of faculty members are very sensitive about the use of their course materials. And so there's a diplomatic question here as well. Institutionally and individually, how much are we willing to use of other people's material, knowing that maybe it's not legal grounds for objection, maybe it is. Let's pretend for a moment like it's not. It's not a legal ground for objection, but it might stir up animosity and concerns from among and other objections that we need to address more diplomatically up front. So that said, putting the issues in this context, that's my presentation. I'll turn to Joe and add to it, or however you want to handle things from here.
You want to take some quick follow-ups?
You decide.
Go ahead. I'll plug back in.
Who actually owns the open syllabus database? So when we talk about
great question.
When we talk about fair use, we're not talking necessarily about fair use for any one of us. In this context, who owns it? On whose behalf are all of these syllabi being put in there, and who would be sued if somebody got mad?
Oh, you've asked about 4 different questions, and I think one of the most exciting questions that you've asked is that very first one, because it's a whole other bundle of issues. Who owns the database? If in fact somebody says, okay, Joe, bright green light, go ahead and download 1 million syllabi, and perfectly legal. Let's assume everything's great in that regard. Now you've got this treasure trove of databases, this database of syllabi. The ownership, all that Joe got was a permission to download. So whoever owns the copyright in the individual pieces has not changed. It's still diffused among those millions of potential players. So that hasn't changed. But maybe the database itself is a newly protectable compilation. And Joe at this point says, thank you for being so open with your syllabus. Now I own it. Now, or at least I own the database. and everybody has to come to me. Joe's not going to do that, right? But, but on the other hand, it could be perfectly reasonable to say we will allow researchers access to this data collection under these circumstances that are reasonably related to furthering research. And at that point, I'm going to be this Iago that whispers in his ear, you see how easy it is to want to have some kind of control? Is there a perfect openness that we're striving toward? Maybe. Maybe not. I don't know. You have to tell me.
But to be specific, is it Columbia University that owns it?
Oh,
right now.
You mean, am I going to give you an answer to that question? I'm not going to even answer that question. And the reason why, here's a basic rule. We all have questions, and this is great, because you're saying, darn it, will you just answer my question? If I said yes or if I said no to that, I would be telling you. I'd be telling you a legal conclusion. No, my job is to help you get your own straight answers. I'm serious.
And now you understand
That's
some
the
of the
role of
difficulties we've had trying to figure out who can provide syllabi to the project. Right? So, thank you for clarifying that. Universities have to give us their syllabi. That's very clear now.
Wait a minute. Did I say that?
Jonah?
Yeah, thanks, Kenny. That was helpful. Can we go back to eligibility for a moment, though?
Absolutely.
I know we talked today a lot about how syllabi are certainly composed of more than just a collection or a sequence of readings. Okay?
Yeah.
But at that level of just the collection of sequence of readings, could Columbia claim copyright over the books in the core taught in that order? In other words, if this project were just about trying to identify which books were used in a particular sequence, could anybody actually say you could not extract that or not teach a course that way?
Yeah, we don't have to point to who, like your question specifically said, could Columbia? You could have asked the same question, could Columbia, could the individual professor? Let's just say whoever the copyright owner is, theoretically, could that copyright extend to the listing of readings for that course? The answer is yes, because one of the pieces of copyrightable works is compilations. And if I have taken the world of readings related to my subject of teaching, calculus, and I've taken the world of readings that I'm going to assign for students to read in connection with this course that I'm teaching, of the multitude of potential readings, I have selected this subset. I have organized them in a certain way. I have arranged and sequenced them in a way that's intellectually appropriate for my course. What copyright can protect is the original selection, arrangement, and coordination of public domain information. So that if somebody else takes my list or a substantial part of it, theoretically, they've stepped on my copyright. If they reach inside and take just a small portion and rearrange them and add their own, then they've moved themselves safely away from copyright. But if they stick with my list,
That eligibility is crystal clear, never gets anywhere near the phone book or any other kinds of
the white standard white pages phone books, do they still exist? Yeah. The Supreme Court ruled in 1991 that standard alphabetical white pages phone books are not protectable by copyright because the selection of who goes in there was determined by not creative forces, customers within a geographic region. That's not a creative thought process. The sequencing is strictly alphabetical by last name. That's not a creative original process as well. So the court said no protection. But if I reached inside that set of public domain facts and selected creatively and organized in an original fashion, then there could be protection.
So, but just to give a slightly different answer to your question, so the project is housed at the American Assembly, which is an affiliate of Columbia University, and for different purposes, or depending on the purpose, we're either an independent organization, 501c3, or part of the university. So, you know, where ownership of this project falls is indeterminable, short of some actual case that would require the university to figure out whether or not we were part of them for the purposes of determining liability or something of that sort. But that's figuring out a long-term strategy for housing the project and establishing, well, you know, ownership to the extent that there's ownership is something that we want to talk through over today and tomorrow. Something we're responsible for, coming up with a long-term management approach to how this project can grow and be housed in ways that are institutionally sustainable, as well as technically and socially, and all the other registers in which this needs to be played out over the next couple of years.
Mm-hmm.
Yeah, but if I could jump in, I mean, clearly, based on the name, you see that we do have a particular, or a desire at least, to make this, if this was under some sort of license, a database, it would be under some sort of Creative Commons fair use open license.
I guess the reason why I'm asking is contributors might be interested. Who are they contributing
Yeah.
to?
Yeah.
Good point.
And where is there, you know, people, tomorrow there's gonna be a hackathon. You know, copyright's very interesting when you talk about little pieces of individual code that end up in some other, somebody else's ownership. So another interesting point about the materials for courses. The Higher Education Opportunity Act of 2008 requires them to be available for students. You have to have citations, you have to give prices, and et cetera. It's, I have no opinion about what that means for the Open Syllabus Project, because the Open Syllabus Project itself is not a student that would be interested in enrolling in these courses. But that might be a way, a pathway, I don't know, to getting some of this data across the entire nation, because it's a federal act. And then I have no idea what individual state laws are that might or might not circumvent any of that, because states charter the both public and private institutions of higher education, and as part of the charter, they might require, hey, school, you must provide such and such data.
So let me talk to some of these issues in the course of my presentation. I think I can get at some of them, or at least the way we've encountered them. So I put this up on the board earlier as a kind of map of the different layers of the project. I want to talk in a bit more detail about the two layers at which these sorts of policy decisions around access and copyright begin to matter. One is where we get the syllabi. So what kinds of arrangements do we need to make with institutions that may be repositories of syllabi that may hold the syllabi? And then how we make, under what terms are the syllabi accessible through our database. So these are two levels. One is our agreements with institutions primarily, and the other is our agreements with users. What kinds of access do we provide to users? And of course they're connected, because the nature of the protections the nature of the access with users will shape the willingness of institutions to play with us. So they're closely related. And just to unpack a little bit, question of where syllabi come from. I mean, in one context, it's the internet. We're pursuing an all strategies at once process as we try and develop norms around the collection and ongoing donation of syllabi. One is just the internet, right? So we've assembled 1.5 million syllabi primarily on the basis of ad hoc identification of sites that appear to have a lot of syllabi. I've scraped those sites. We've acquired a bunch of little collections from people who've been in the business of aggregating them over time. That's gotten us to 1.5 million, but it's very ad hoc. We do not have a general approach to regular crawling and scraping of syllabi from the internet. So that's something that is a technical problem that we can come back to later, but it's definitely something we need to begin to think about how to implement. There are some notable, there are some conditions that make this more or less easy. I mean, one, although there are no consistent norms around the publishing of syllabi, some states have required more or less transparency with regard to the publication of instructional materials. So you mentioned the Wisconsin case. That I spoke to them about. This is a National Teachers Quality Organization Association.
Yeah.
So in the context of trying to develop some metrics for measuring the quality of teaching and education schools, they tried to collect syllabi and ran into a brick wall with a lot of public institutions. They sued the UW-Madison system under an open document records request.
State.
The state, which ended up being hugely contested. It settled ultimately, and Madison handed over the syllabi. But from our perspective, it's not an approach we want to take. Where suing university systems is a guaranteed poor use of our time. So, and that's true at lots of levels. So we're faced with a situation where we need to create some easily replicable templates for access. Those need to be, we need first mover institutions who can create a certain degree of comfort for other institutions to adopt the same models. We've tried to push those conversations with a couple of the institutions that are sort of most closely related to people involved in the project. That conversation is ongoing with Columbia, and we'll talk a little bit more about that. We have, just in function of having scraped the Columbia site, several thousand, maybe tens of thousands of Columbia syllabi already. So what we're really asking for is access to the larger corpus collected through the learning management system, through the coursework system, and an agreement for ongoing donation of syllabi as each year generates several thousand new courses, and as that system becomes more regularized and better structured. That's the kind of relationship we want at the institutional level. But just coming back to the internet, so that it turns out that the state that has gone the furthest in adopting open instructional materials requirements is Texas. Our biggest corpus comes from having scraped, I don't know what percentage of the public schools in Texas, but a large percentage through Linda's work. It's been an extraordinarily fertile and wonderful resource to have. We can make claims to being, having a genuinely representative corpus from the Texas state system. Texas is way ahead of other states on this, and for reasons that you can correct me. I may give an apocryphal version of this, but it's the one that sort of suits my own mental map the best. Yeah. How do you pass a genuinely strong open access requirement for instructional materials? And California can't do it. Texas can do it, and it's part because the notion of open access to instructional materials was an important issue for conservative activists who were concerned about subversive teaching in the schools. So
I'm sure that was probably it, even though they got that perfect, the student didn't get what they want, and now we can go in and put our agenda in and say, you want our money, then,
Yep.
You're going to have to, and your CD to make sure that, you didn't go to Berkeley in the 70s.
Exactly. So, one of the things we can now do, and I'm not saying this is a good idea, but we could sort of realize the Texas activist dream of creating a Marx mapper for the state of Texas. Right, this would be a good sort of first level application of the system. And I think this is the concern, the idea that there's a giant cluster of
Groucho and Zeppo out there.
But for all the wrong reasons, it's created this remarkable resource for us, and we'll eventually want some legal advice on whether we can treat these as open access documents. I mean, at some level, they're as close as anything in the country. I don't think there's any CC licensing associated with these requirements, but they're being treated as documents that are by law required to be publicly accessible.
Right,
And-
so it would be all over the world.
Well, and then can we also make them publicly accessible on those? Can we make the full text publicly accessible on that basis?
And that's what I was going to ask you a quick question. Some of them I got permission from, a few, because you were supposed to be able to get this
In Texas,
syllabi,
from Texas institutions, right?
from all public ones, and they were supposed to be no more than 3 clicks away from the home page, and a lot of times they weren't. And I got pretty good at finding them, the little buggers, but sometimes I would send an email and I would say, we would be honored on the Open Syllabus project if we could, add your syllabi. Now,
Right.
if they came back and they gave me then the how to get to those websites, is that a de facto? I told them it was for the Open Syllabus project, so they know what it's for. And it was from, usually it's from the chancellor, vice chancellor. I just went to the top. And is that a de facto okay? Then if I said it's for them, and they said here you go, this is how you get them. Is that is that permission?
I'm actually going to answer your question. You ready? And the absolute positive answer is, that depends.
Whether or not they have the work contract.
Yeah. Well, I won't get you off track here, but it sounds a lot like permission. It might be kind of an implied permission to use in certain ways, but even at that, it has to come from that permission from the rightful owner. So, in other words, I can't give you permission about something that Joe owns.
Right.
So we're chased back to the question of it depends. In Texas, is this Texas institution
Generally,
say we own?
The contract you sign with your public institution is that they have the rights to everything you do.
Now, I've seen great variation on that.
That's true.
So let's say an institution does have that it's a true ownership by the institution.
Right.
I would want, as a lawyer, I'd want to work with you to word it more clearly. But if you've got something like what you described, it starts to look like an implied license to use it in the context of the project. But that the next institution doesn't have that same arrangement with the faculty and leaves rights with faculty, then it doesn't sound so promising.
And it wouldn't make a difference from whom I got that
Correct.
permission also.
Correct.
Okay.
So we have an institutional approach to this question. So let me just jump ahead. So there are a variety of different levels of permission that we can, or the different ways of getting the materials, we believe, put different constraints on us regarding how much of that material we can then expose to users. And so anything that is clearly open access sourced, things with a Creative Commons license, maybe the Texas corpus, we can then republish that. We can provide full access to that, to those documents. And those can enable certain kinds of applications, right? So if you want the syllabus browsing tool that allows you to look at the full syllabi of what people are doing, they're really only legally safe way of doing that is to only provide access to things for which we have very strong confidence in the level of permissions that we can either get from the copyright owner or through a Creative Commons license or through other kinds of implicit sources. So that's, for the moment, that's a rather narrow corpus. If the university makes a strong claim of copyright ownership, we can get it from the university. The university is the rights holder. More often than not, we're going to present materials to the end user in a much more restricted form. We are not making the full underlying documents available. We're making the analytical results of extracted metadata available so that you're several steps removed from the underlying document and the associated rights claims. We are making transformative uses of these documents on the basis of metadata that we've extracted from the documents. And those take us into pretty strong fair use territory that means that for that corpus, and that corpus includes probably most, if not all, of the 1.5 million documents we have, the end user does not get to see the documents themselves. They're seeing statistical outputs of the tools that we build on top of those documents. Most frequently taught texts, you can divide, most frequently taught texts in Texas, most frequently taught texts in Massachusetts. Comparison of institutions, and there are a whole range of things, and most of the things we've been talking about are really conditioned, they're designed to be built on top of extracted metadata, not require exposure of the underlying documents. So on that basis, other options are on the table. That's the premise of our use of documents we've collected from the internet. It allows for university fair use claims, so that if Columbia wants to give basically everybody's supportive of the project, but everybody fears that at some level they're going to run into a faculty buzzsaw. Right? The goals of the project are quite clear. They're quite, quite appealing. But everybody fears that at some point faculty is going to raise a stink, because most of the ways in which these debates about copyright have been implemented into university policy over the last decade, because there was a big round of fights around ownership of instructional materials a decade ago. They've never been tested. They've never been applied in any ways that would really trigger renewed consideration of whether these were appropriate bargains with another generation of faculty. So this is the concern.
Can I just jump in for a moment, Joe, to say one thing? A lot of times, in my experience, it's easy to speak about faculty as though they're an atomized force, as though it might be one famously disgruntled faculty member. But in many cases, I think there also may be a structural reluctance on the part of the institution to engage in the activity that might provoke, for example, an unionized faculty member. And so it's not so much a question of a faculty buzzsaw so much as it is a kind of like a structural condition of employment where there are larger aggregations. That's a great point. And the relationship between the institutions is more critical.
Yeah. But so we think it's pretty unlikely that we're going to find a university partner willing to assert copyright ownership and then grant us those syllabi on the basis of open access principles. That's to our mind, declaring syllabi to be open access would be the ideal endpoint. I think none of us here think that teaching should be a secretive process based on secret recipes, right? That's kind of antithetical to the whole project. But we think that there's a lot of work to do before we convince many universities of that fact and create mechanisms that also make that seem like the right decision for individual faculty members.
But then again, you'll get there are exceptions to every rule. Yeah, I agree. Most if not all of our teaching really should be open to a great extent. But on the other hand, then you get the individual faculty who's really taken a beating for teaching controversial subject matter, and external parties deeply criticizing the content of those courses. And we all know that that's happened in many places around the country. So there are many issues here.
So we think the safest path through this for the universities, and we're trying to make this case, is that premised on the Open Syllabus Project only exposing metadata and the results of analysis on the metadata, the universities can in turn make a fair use claim to give us those syllabi for purposes that relate to institutional research, for a range of purposes that do not reinvoke the ownership claim. They're making fair use for institutional purposes of materials that they hold.
I think that's what Mark Davis did with Brigham Young, right? Brigham Young, Mark Davis's corpus of contemporary. It's COCA, C-O-C-A, Corpus of American Contemporary English. I don't think that I have it quite right, but of course it's 450 million words. He also has it's diachronic. And when you go on and you do a search, that's what you find. You can click on, if you do a word search, for example, you click on the word, you can also find the text that comes from, Sometimes it is perhaps the entire text, but somehow he worked it out because you've got articles from newspapers, journals, parts of books, of course you can't do whole books, and all kinds of different sorts of documents. And so if Mark was able to do this, then somehow we must be able to do the same thing. I would think. I mean, I would think anybody who has put together, whether it's the Brown Corpus or, you know, the American, whatever they did, they went through exactly the same thing, and they were able to make these searchable corpus. And they sell it, not Mark Davis, not at Brigham Young, but, you know, these other ones are sold. So somehow...
So this is something that should be on our agenda for tomorrow, because you know, one of the things that we need are a better accounting of the other experiences out there with similar kinds of problems, and that's something that I think a lot of you will know a lot about, and we know some of it, but not all of it. And you know, as part of the larger sort of mapping of the project that we need to do in the course of it, you know, this, and we'll get to some of this later on too. Yeah, I mean, if that model has worked somewhere, we absolutely want to know about it.
Mark's
but we think
very
this,
approachable, so.
But I think this is our best case. Now the trouble scenarios for us are to hear. I mean, centralized authority decision making is the only feasible one for us, because we don't have the resources to engage with lots of universities at once, because these are all very labor-intensive conversations. And we certainly don't have the resources to pursue it if the provost's decision is to kick it down the chain to deans or departmental chairs or worse, individual faculty.
Can I just ask Kenny really quick? I'm wondering if a point of entry, what I see is there's a huge exposure among universities in terms of anything they put online has to be compliant across the board in terms of ADA compliance. And it seems to me that that's, you know, the same things that drive web accessibility also drive openness in the gathering of data. And so without speaking to the fact of whether or not there's enforcement right now, because we know there isn't, is that correct that there is this, you know, potentially unlimited exposure for all these documents out there?
Yeah, I others may be able to answer more about exactly what ADA requires. But it's a reasonable access kind of requirement, and so that doesn't necessarily mean public access. It's really reasonable for that student. So I'm not sure that ADA compliance is going to open up the door for these non-ADA objectives that we're thinking about for the most part today.
Unless they don't know how to make their documents ADA compliant, which is a matter of structure, and it seems to me it kind of leads right into, you know, being able to parse that data as well. I think that the project could say, we can help you with this problem, and then if you want to contribute to us.
Mm-hmm.
Well, so let me circle that point in some fashion. So the worst case scenario is that we hear from universities that we need individual faculty permissions, that they're just going to wash their hands of any attempt to make decisions at a higher level. In that case, we have some recourse, and in fact, like I said, we're pursuing this on we're pursuing all paths at once because they're all long conversations. But the universities are the control point for any kind of repository of syllabi. The other actor that we can talk to, of course, are the learning management systems that are, you know, supporting the collection of these syllabi. The rights rest with the university and the faculty in some form, but the learning management systems are not helpless actors in this space. Most of them have implemented tools for publishing syllabi, for declaring them public documents. There are a lot of ways in which individual faculty members can elect to get their syllabi out of the LMS, right? Those are not very standardized. They're not operating according to standard syllabus schema. There are a variety of they're archived in different ways. Sometimes they're posted to the web. Sometimes it's just a statement that doesn't lead anywhere. But we think there's quite a bit of potential for developing some basic standards or protocols for the learning management systems to adopt a range of much more explicit buttons to publish. One of those buttons could be to publish to the web. One of those buttons could be, I don't want my syllabus to be public, but I support the goals of the Open Syllabus project, so archive with the OSP. You could ever, these things already exist to some extent, but they're very non-standard, and they're as diverse as the syllabi are not very well standardized within most of the learning management systems themselves because they're unstructured. They're also treated as a kind of ephemeral document. So those are conversations we've begun to have with some of the learning management systems operating in this area. You can see this chart. I don't know how accurate it is, to be honest, but I pulled it off the web, and it's at least reflective
It's free.
of the.
It's free.
It's free.
It's gotta be good.
It suggests something about the range of players that you need to talk to in order to be effective at that level. And so, like I said, we're a very small operation, and we don't have the resources to have start long negotiations with each of these at once. But we're starting to broach these topics of how they can help independent of what the universities do. So the university doesn't have to say yes. The university can be out of the picture at that point, for the most part, or wouldn't have any substantive legal basis for objecting to giving faculty an option to dispose of their rights in some other way.
Are you sure the reverse situation isn't true? Let's just assume the university is very focused on, I own these pieces of material, and then they're provided the right to let them go.
If nothing would make me happier than strong university claims of ownership.
You got to be careful. That was captured on tape, and
just from a practical standpoint,
it's extremely pervasive in certain areas, like the for-profits, because they operate like businesses. They are businesses.
Yeah. So the problem is some of these conversations have a duration of years, right? If we're arguing, or if we're negotiating with LMSs to develop new features that need to be integrated, I mean, it's a 3 to 4 year arc to get any of that done at a minimum. The university conversations are also slow, but hopefully on a faster time frame. We can scrape the internet all we want and dump it all into the database, and on the basis of our fair use claims, scrape for metadata and make those metadata results available. There's one of the problems so far is that these models haven't really consolidated. We're still pretty early days in terms of these institutional conversations.
And if you go back a slide, like one of the things I see that's sort of an inherent tension here is that you could spend energy working towards better approval or whatnot in order to essentially embellish or emphasize the full text access. Or you could spend a lot of your energy actually doing all of the metadata and whatnot and kind of shove aside this other problem and say, look, our real focus here is going to be all of the metadata and analytical output, and not put as much energy. Now I know they're not necessarily mutually exclusive, but maybe you just say, document search isn't as important a tenet of this project.
And realistically, that's where we are now, and it may be where we are next year, but over time this is also a project that would like to see more open access policies in place for syllabi, and that's something that requires the university and LMSs as partners. Jonah?
So one variation that I don't see up there is self-deposit. Now, I don't doubt that it'd be difficult to get big numbers there. I'm wondering if, first of all, that would throw off the sampling at one level, but more importantly on the legal side, I mean, the Creative Commons licensing is a way of indirectly making a handoff.
Right.
But what would be necessary on a self-deposit form for somebody to assert, such that they could put this in for your project without necessarily relinquishing other rights?
That can be done really, really easily because in fact, if you look at typical university repository that receives articles and other kind of content created by faculty, there's a statement that you can click yes to, and we hope everybody read it. And it would say, this is mine, you have the right to deposit it, and then usually it's not compulsory to do a CC license, but options then are offered up. That's typical. And we just hope that everybody has it right. We all know, we're learning from experience, that doesn't always hold true. Publishers are coming back to some repositories now saying, that's my stuff that I found in your repository. So there's a little bit of pushback from other copyright claimants.
I mean, I get the ambiguity of ownership, but in other words, for faculty to assert ownership and self-deposit for this project could be another pathway.
That's absolutely another pathway. I'm drawing some lines of disruption to take this copyright cycle and how we could break it up, because we'll go to permissions and access, because we have this whole thread of access, lingering out there that we're talking around. Somebody can provide that access. We can disrupt the fair use analysis by giving a CC license up front that takes care of that. We can disrupt this broad scope of protection and expansive legal rights also through a CC license. So there are a number of things, and these are very legitimate, very good things to do. There's nothing copyleft or anti-copyright in any of this. This is an exercise of your rights as a copyright owner to make these good things happen.
Dennis?
I have a quick 2 footnotes. So first one is that we do have I'm happy to announce is that we do have a method to self-submit, and you do it through Twitter by tweeting to OSP submit with a link to a syllabus, and we automatically just have a Twitter bot that sucks in anything that's been tweeted with OSP submit. Now, we have not tested this extensively yet, and that's why I have not announced it, but the engineering is there and it actually works. So you can try it out, and we can see tomorrow whether it's actually properly getting ingested. OSP submit, yeah, so that's kind of a very passive kind of ingestion that we are going. So that's number one. And number two, again, another little footnote, is that all the coding, so there's separate licensing here. The big difficult question is the licensing and the issues around the archive and the database. The coding, the code that we all share together, that's easy because it is a license under the GNU free open license. It's under our GitHub, and all of the documentation that is under CC, non-commercial, whatever. You can go to the license portion of our GitHub page and see that licensing. That one is easy because that one we are completely in charge of. So. Yeah.
So just, Burl, not to put you on the spot, but you want to be a listener or a talker?
You better introduce
I've been a listener for the last hour. I'm a lawyer in the general counsel's office in Columbia.
And an excellent person to work with.
So a lot of this conversation passes through Burl's office, which.
Yeah, and I mean I can speak only for Columbia, but well, actually I know a little bit about others. I mean a lot of these questions are determined by university policy, and Columbia has a copyright policy that gives answers to some of these questions. However, I think that, and I'm really speaking for myself here, I haven't discussed this with anybody else. I mean, I think this is the kind of use of the syllabi. I mean, I think this is something the university would want to have some kind of buy-in from the faculty, just as a policy matter. So, I don't know, that's my take on the lay of the land here.
That's that diplomacy thing.
Right, exactly. Yeah, I mean, so to the extent there's an ownership claim to the syllabus, in general, I think they would be owned by the faculty, or the university do not claim rights to it. There's an exception for what are called institutional courses. So somebody had mentioned Common Core courses. So there may be a set syllabus for the Common Core at Columbia. Nobody's ever asked the question, but my analysis would be that that would be owned by the university, but freely used by faculty here. course.
I'm wondering, do professional journals offer a model for encouraging submissions from the individuals or from universities? You know, when people spend lots of time creating these articles and they don't get directly recompensed for them at all. And so that kind of, looking at what the value propositions are in terms of the peer-reviewed journals, and as some of them have gone to digital, does the project have the ability to offer some of that kind of value in terms of exposure for the ideas or status or?
Can I respond to that? Yeah, I would really like to respond to that. That's a great point. There are real answers, but I think that there are multiple answers. They're all equally real because there's no one answer to cover all situations. So a lot of journals have gone to open access, free, which is defined in many ways. But let's take the outside definition of open access, the fullest definition, that it's fully accessible by anybody with an internet connection. So there's no password or no fee, and has a Creative Commons license attached to the work. Now, to make that all happen, somebody has done the hard work and spent the money to build this journal and to provide the screening mechanism that pulls in those articles and applies those terms of use. Whereas the individual faculty member typically doesn't really want to think very much about these issues. They're really worried about getting their biology, their chemistry article done and published. So if somebody else is handling this for them, so think about this deposit mechanism via Twitter or any other communication tool, that could become that method. But notice we're talking about, compared to 1 million syllabi, we're talking about a handful of articles by comparison. So it's a slow process. We also know, from experience, that a lot of availability via the web is illusory because a lot of us in the academic setting have access to all of these fabulous journals. But we have that access because somebody across campus has spent $10 million buying that for you. You may say thank you anytime you want. And really, unfortunately, a lot of faculty just don't realize that. They say, well, what's the issue? It's all there on the web. It's all there on the web for you because somebody has purchased it for you. So, I think that there's potential in your model. I still see a lot of potential in it. But mind you, scaling it to 1 million syllabi is going to be a hard path.
And we are talking to the MLA. MLA is interested in the project, so there's a way in which the professional associations could provide a kind of reputational boost, for sure.
Yeah.
We've toyed with and deferred the question of building a kind of social layer onto the site that would allow people to develop their profiles and claim syllabi and create kind of authentication for what's submitted. That's a direction we could go down the road, but it's several several layers, degrees of ambition beyond what where we're at right now.
And actually, let me add then that I think a place where there has been acceleration in open access to the scholarly content has been where it's been required by an external force. The NIH requirement is there because Congress passed a law and said you've got to do this if you take NIH funding. And we're seeing that expand this year out to about 10 or 12 other federal agencies, and we're seeing private funding agencies also get into this process because they know that they have the leverage to make this happen as funding agencies. Funding agency for a syllabus is the university that issues a paycheck. So can we take this model and think of it in these other terms and other ways of managing, as I often say, being good stewards of the intellectual property that we create at a university.
But I mean, in terms of the university creating incentive for faculty, such as at Harvard, Stanford, at Columbia as well, for having the commons, having the scholarship be available through faculty web pages or a central deposit. What is the relationship between the syllabi that we produce then and its applicability, its sort of implementation into university-wide open access policies? Have you had any conversations on those issues with universities? As in, why can't syllabi be treated in a similar way as scholarship is?
Excellent point. I think the short answer is, because we could talk at length about this, and I would love to do it another time, but I think that there is real potential. I think your point is akin to the other, and I think there's real potential, but keep in mind that all of those open access policies you mentioned, that they exist by virtue of votes of the faculty to consent to it.
Right.
Which takes us back to the diplomacy question, which takes us back to General Counsel's point that it's probably important to have faculty buy-in on many of these decisions. So in other words, a model would be, let's take it to the faculty, let's get their buy-in on this. That is a model, has advantages and disadvantages, but it's a model well worth considering.
I think an interesting parallel to think about is how learning outcomes have gotten onto syllabi in like the past 5 years, and it's interesting because we act like these are documents that never change, but actually, and many faculty members really hate learning outcomes or really hate them to include that, but somehow there's been this massive effort, and it's changed, and there's been compliance, and it has been put to faculty. I remember working with the faculty body to get the groups of people to pass what the learning outcomes are for curriculum, and like this kind of mobilization that you think never happens in academia. So I think we have seen things like this happen in the recent past.
And just to this point too, how you get faculty buy-in. I think we do that in part by demonstrating the value of the tools to faculty. And the clear winner here is most taught texts, right? People want to know the frequency with which their work is taught, especially as they begin to publish things in open access or other kind of gray
is it showing
formats.
up?
Is it showing up? That it has the potential to create a completely new metric for all the things that faculty need metrics for, right? Promotion. If you've written one article in the last 5 years, but it's one of the most taught texts, you have no way of owning that at present, and
even learning it,
or even knowing about it.
I'm going to talk about that in my piece, using tools that already exist like Altmetric to discover references to anything with the DOI. It doesn't even have to be an article. It could be a figure and picture. It could be a data set. If that's being cited in the syllabus, we can discover it. And oftentimes, faculty members who are authors of those pieces of work that are being cited have no idea that their work is a centerpiece of somebody's Intro to Economics 101 or what have you. And that could potentially create a bridge between that author and this next generation of students.
So it's chicken and egg. I think we begin to develop faculty support when we begin to deploy tools that meet faculty needs. But the problem is, we're working on a year-to-year time frame, and a number of these are conversations that play out over multiple years. So it's a fragile moment for us where we need to start. We need to get you involved in building tools that make use of the database and that allow us to put it on a better, more sustainable footing. Dennis,
maybe
two comments or questions, and we'll wrap up.
This is more of a general thing than specific to this, but since social impacts is one of the topics here, I think it's interesting that we're seeing with publication, perhaps of all these syllabi, we might see a sharper division between a teacher's mastery of a material and the teacher's ability to convey the material. They won't necessarily have to come up with the syllabi and the learning outcomes and the text anymore. They won't have to know that material to know what outcomes should be taught and materials to use to teach them. But it will be really important for them to be a great teacher. And it's a possible impact that might concern a lot of professors and teachers, hey, my knowledge is not so important. My ability to convey that knowledge is now that much more important.
And faculty write to the system of rewards that allow them to measure their contributions, and if research citation is the primary metric that they respond to, then they're, that's going to shift faculty writing in a particular direction toward abstruse, high-level journal or research journals. If they can get rewarded for writing, broader audience material that's suitable for teaching, then we have the potential to shift the incentives that structure faculty writing, and that's to me that's very exciting. Since I've it's a longer story. But Dennis.
Yeah, I just want to quickly jump in to say that if you remember kind of our milestones and our kind of plan of action, the reason why we want to get to a critical mass is to actually bring people to the table and encourage them to have that conversation, the conversation of intellectual property, right? Exactly like we're beginning to have now. And I really would like to see more of that, and I'd like to bring in more faculty, more administration. And if this is, so we ran in the Chronicle of Higher Education, there was a little piece, and of course you had a bunch of people comment and say, oh my God, you're killing education. And this is good, so the fact that this is a scary conversation to have is good, because at this point we're in that uncertain moment. We don't know what the rights are. We don't know where kind of the responsibility belongs. But I know now that the archive and the database is being developed in a transparent, open way, and it's a conversation that we still have, we still can have, and we still have a choice here. Now, if we are able, a kind of a ragtag group of people, are able to pretty quickly collect a significant corpus like that, it's very easy for other corporate interests, private interests to do exactly the same thing, and at that moment, there won't be a conversation. At that moment, it might be that we're put before kind of a choice. And I'd like us to start having that conversation before it's settled, right? Before we're just forced to make some sort of reactionary decision. So this is great. Like it's exactly what I was hoping that would happen. This kind of diversity of opinions and viewpoints that you see in this room. Yep.
Yes. I wanted to jump in. It's interesting, Kenny, as you were going back and reviewing the map that you had done, you started pointing out areas where different sort of issues can be unbundled a little bit and looked at it in terms of sort of disruption, not in the sense of the sort of generic sense of laying waste to the entire sector, but rather looking at conversations where there's a kind of sedimentation of assumptions that are not really warranted and maybe not very helpful. Now, it seems to me that what's happening with Syllabi, and I saw this through my work with the Faculty Senate in the School of Dealing with Power Systems, is that when you speak to a faculty member, there's like the larval stage of the faculty member, there's many different stages of the faculty members, and they're all kind of operating at the same time. And so, for example, you'll find that faculty members will feel as though, on a certain level, they'll feel as though they're a member of the precariat and will be extremely defensive about things that are theirs, or that they receive.
That's right.
Then there's another way in which they will tend to try, not very effectively, but try to speak in more kind of like solidarity terms about, for example, issues having to do with workload, issues having to do with intellectual property, issues having to do with sort of, the different sort of measurements associated with the careers being, with reward and promotion, these kinds of things. I would like to suggest that one of the things that we do tomorrow, and I really want to make this plea, it's billed as a hackathon, which sounds as though it is a primarily technical venture. But tomorrow should not primarily be a technical venture. There should be parts of it there. But one thing that we'll really need to do, I think, is put together a working group, like a working group or two that are thinking about these different kinds of conversations, who we can have them with, and how we can have them in ways that can begin to map out very clear focus strategies for the OSP. I'm going to go back quickly. When you began your talk, you were talking about eligibility.
Yeah, way back at the beginning of the cycle.
And you mentioned that some of the criteria for eligibility involved selection and sequencing.
That's for specifically for the compilation copyright.
So if we were to go back to the origins of the big books movement, right? or the great books.
Great
movement.
books.
I mean, the notion that, for example, Columbia owns the canons of Western civilization on a certain level, I think, is a ludicrous proposition. On the other hand, it's the kind of
Kinda cool.
proposition that we would not be terribly surprised to hear some company make within the next
Right.
4 or 5 years or something like that.
Wouldn't be shocking.
So we're seeing the meaning of a single object unfolding and changing quite dramatically sort of under our feet. But then at the same time, this genre called the syllabus is becoming more sedimented with boilerplate, with learning outcomes, in many cases that are specified by accreditation agencies or negotiated through organizations that are accrediting schools that are sort of beginning to specify in a more articulate way how curriculum should unfold. So the argument that I would like to make, and it's again as a plea for thinking about the hackathons, to begin to start to disassemble the genre, like I think what they call in biblical studies, like kind of form analysis or something like that, to be able to kind of like decompile the syllabus into different sediments so that we can potentially make an argument that there are some sectors of this document that can be copyrighted, and then there's other strata or layers that cannot be, right? And the document itself, it's a bit illusory to think of it as a single document, but rather it's in itself it's a corpus with many, many different stakeholders and owners. And that obfuscation of ownership provides a path for the OSP to take possession of them and work with them in an articulate and respectful way. Sorry for that.
No, it's okay. I hope we can pick this up tomorrow.